So, you were arrested for something in California and it was dismissed because the DA never filed charges or you were not proven guilty. I said them, not me. Now you're wondering if you have a criminal record, and if so, how do you get rid of it? Well, you've come to the right place. This video is going to explain how to seal a criminal record in California and what it means to be factually innocent. If your records are in another state, or if your California case resulted in an adverse finding such as a conviction or diversion program, you need to see one of our other videos. Okay, here we go. In theory, every time a person gets arrested, paperwork is created, and that paperwork creates a record. Nope, other kind. The arresting agency in California sends that record to the California Department of Justice. The California Department of Justice then sends the record to the Federal Bureau of Investigations.
All the way to the FBI.
Scary, right? And what Mr. Lecter didn't tell you is that unlike negative things on your driving record or credit report, which eventually go away on their own, the arrest records remain on your FBI record until you're about 110 years old. That's unless you get them sealed. And here's the good news. California Penal Code Section 851.8 allows you to file a motion and request a hearing on the matter of sealing a criminal record that did not lead to a conviction or other adverse finding. The court doesn't even charge you a filing fee. But there's a catch. You have to prove to the judge that you were factually innocent. Yes, there are different kinds of innocent. Even Britney Spears knows that. Factually innocent is much different than legally innocent. Legally innocent means you were never found guilty beyond a reasonable doubt. Factually innocent means no reasonable cause exists to believe that you committed the offense for which the arrest was made. It is a much, much lower standard. And unlike in the original court case where the prosecution had the initial burden of proof, you have the initial burden of proof in a motion to seal a criminal record. The all-American notion of innocent until proven guilty is irrelevant under Section 851.8. There's another important legal definition that you need to know that is contained in the definition of factually innocent. That is, reasonable cause. Reasonable cause is a well-established legal standard. It is defined as that state of facts as would lead a man of ordinary care and prudence to believe and consciously entertain an honest and strong suspicion that the person is guilty of a crime. So the bottom line is this. To get criminal records sealed under Penal Code Section 851.8, you need to convince a judge that facts exist which would lead no person of ordinary care and prudence to believe or consciously entertain any honest and strong suspicion that the person, you, were guilty of the crime for which you were arrested. It is quite a catch, but it can be done. Each crime has elements, and all you need to do is present evidence that makes an ordinary person believe that you did not commit just one of those elements. The evidence that you can present can include your testimony, police reports, photos, written witness testimony, just about anything you can think of. You can show direct evidence, and that's evidence that supports the truth of an assertion, such as a vehicle registration that shows you actually own the car that you are allegedly stealing. You can also include indirect evidence, and that's evidence that creates inferences, such as your rap sheet, which shows you have no history of violence, therefore it is unlikely that you would have committed the crime of assault when you were arrested. The prosecuting attorney, that guy, will most likely be arguing why you are not factually innocent and why your record should not be sealed. It is kind of like a mini trial with no jury. And while it is not impossible for the average person to handle this matter, most people will be better off having the matter handled by an attorney with lots of experience doing criminal record sealing cases. If you're able to prove factual innocence, the arrest and court case are deemed to have never occurred, and you could legally deny them in all instances. The judge will order that the arrest records be immediately sealed and then destroyed as soon as it's been 3 years from the date of the arrest. If you have questions or comments about this video, please feel free to post them below. Laws are always changing, so please click subscribe and follow us on social media to stay up to date with any changes. If you want to see if you're eligible to have your criminal record sealed, please visit RecordGone.com. Thank you for watching RecordGone TV.